U.S. versus Bishop. If you have relied on prior decisions of the Supreme Court, you have the perfect defense for willfulness. U.S. versus Minker. Because of what appears to be a lawful command on the surface, many citizens, because of their respect for what only appears to be a law, are cunningly coerced into waiving their rights due to ignorance. Brady versus U.S. Waivers of constitutional rights, not only must they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. Ziegler versus Railroad. If any question of fact or liability be conclusively presumed against him, this is not due process of law. Schur versus Cullen. For a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction or penalty imposed on one because of this constitutional right. Marbury versus Madison. The Constitution of these United States is the supreme law of the land, and any law that is repugnant to the Constitution is null and void of law. Vulgar versus Kansas. Under the United States Republic's constitutional system of government, and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct due to others, leaving one the sole judge as to all that affects oneself. Miller versus Kansas. The claim and exercise of a constitutional right cannot be converted into a crime. Miranda versus Arizona. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Cooper versus Aaron. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Indeed, Gibbons versus Ogun. Persons are not subjects of commerce, and not being imported goods, they do not fall within the meaning founded upon the Constitution of a power given to Congress to regulate commerce and the prohibition of the states for imposing a duty on imported goods. Penhallow versus Doings. Administrators define governments distinctly. Governments are corporations, inasmuch as every government is an artificial person, an abstraction, a creature of the mind only. A government can deal only with artificial persons. The imaginary, having no reality or substance, cannot create or attain parity with the real. Murdoch versus Pennsylvania. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Shuttlesworth versus Birmingham. If the state converts a liberty into a privilege, the citizen can engage in the right with impunity. Owens versus City. The state is prohibited from violating substantive rights, and it cannot do by one power, for example, police power, that which is, for example, prohibited expressly to any other such power, for example, taxation/eminent domain, as a matter of law. U.S. and U.T. versus Daniels. Nor indirectly that which is prohibited to it directly. Fairbanks versus U.S. Hofsummer versus Hayes. The courts are not bound by an officer's interpretation of the law under which he presumes to act. Rodney Dale. Class versus North Carolina Department of Transportation. Police Department is not an agency of the state. Owen versus Independence. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know law. Sapp versus Tallahassee. It is not the duty of the police to protect you. Their job is to protect the corporation and arrest code breakers. Michigan versus Duke. State police power extends only to immediate threats to public safety, health, welfare, etc., which driving and speeding are not. Hollander versus Lawson, in which the United States Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. State versus Robinson. An illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the same right to use force in defending himself as he would in any other assault and battery. Adams versus State. One may come to the aid of another being unlawfully arrested, just as he may where one is being assaulted, molested, raped, or kidnapped. Thus, it is not an offense to liberate one from the unlawful custody of an officer, even though he may have submitted to such custody without resistance. California versus Farley. Speeding, driving without a license, wrong plates or no plates, no registration, no tags, etc., have been held to be non-arrestable offenses. People versus Battle. Traffic infractions are not a crime. Kent versus Doles. The right to park or travel is part of a liberty of which the natural person, citizen, cannot be deprived without due process of law under the Fifth Amendment of the United States Constitution. State versus Armstead. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. Thompson versus Smith. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right, which he or she has under the right to life, liberty, and the pursuit of happiness. Chicago Motor Coach versus Chicago. Gare versus Chicago. Boone versus Clark. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right, which the public and natural people cannot be deprived. Christi versus Eliot. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public, and such a traveler owed no other duty to the public, example, the state. He or she and his and her auto having equal right to and on the roadways and highways as horses and wagons, etc. This same right is still substantive rule in that speeding, running stop signs, traveling without license plates or registration are not threats to the public safety, and thus are not arrestable offenses. Boyd versus U.S. The court is to protect against any encroachment of constitutionally secured liberties. Griffin versus Matthews. Lack of federal jurisdiction cannot be waived or overcome by agreement of parties, and want of jurisdiction may not be cured by consent of parties. Louisville versus Maltley. If a tribunal, court, finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. Burns versus Superior Court. Ministerial officers are incompetent to receive grants of judicial power from the legislator. Their acts in attempting to exercise such powers are necessarily nullities. Aces versus U.S. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. U.S. versus Will, Collins versus Virginia. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. Bonneke versus Massachusetts. A writing is void ab initio in the case of fraud in the inception, and it need not be formally rescinded as a prerequisite to right of avoidance.